So you may have created and signed your Revocable Living Trust. If so, congratulations. So now you might be thinking, what next? What do I do with this trust that I think of like a basket? Well, this video is all about how to fund your trust. That is, how to move things into the trust and how to name beneficiary designations. So the first question you might be thinking is, when do I fund my trust? Well, you can fund it right when the trust is signed. And let me add, if you have an amendment to your trust, you can always fund your trust. You can always retitle things or update beneficiary designations once you have a trust, the original trust that has been signed. So you'll have different types of assets, and each asset needs different treatment. So I'm going to go through each of the assets that you might find, that you might have, and see what do we do with each of those assets. So the main one I want to talk about first is your real property. What to do with your real property? Well, we or somebody will create a deed that you sign and that we record with the recorder's office. And that is what retitles that property into the trust. So once it's, let's say, John and Jane Smith, they hold it as, joint tenancy or community property with right of survivorship. Once you record a new deed that says now it's owned by John and Jane Smith, trustees of the John and Jane Smith Family Trust, now it's in the trust. So that's how we put real property into the trust. For California properties, since I'm an attorney in California, I'm happy to help transfer California properties into the trust. If you have properties in another state, you'll need to work with an attorney or a deed company in that state to help you transfer those assets into the trust by doing a deed under the state laws where that property is located. Okay, so you may have brokerage accounts, mutual funds, CDs. All of those should be retitled in the name of the trust. So again, what does that mean? That means if it's currently held as John and Jane Smith as owners, the owners, when you look at a brokerage statement at the top left-hand corner, what it should say when you retitle it is John and Jane Smith, trustees of the John and Jane Smith Family Trust, or maybe it just says TEES, which is a way that we initial or we shorten trustee. Now, sometimes the banks will allow you to retitle an already existing account, and sometimes they'll create a new account and they'll put the title of your trust on that new account, and then they'll transfer the assets from the old account to the new account. So it just depends on what the bank wants. A lot of times you can provide the certification of trust that we've prepared. You can provide that to the bank, and that gives the bank all the information that they need to retitle accounts. Sometimes they'll have you fill out a form answering different questions. Is this trust revocable or not? Who has the power to sign? Who are the settlers? Who are the trustees? That sort of thing. And so you just fill that out and you provide it to the bank. Now, what about small accounts? Like, let's say you have a $20,000 checking account that's attached to your direct deposit, perhaps, or maybe it's not, but maybe that's just your spending money, that's fund money. You make sure it stays small. That you can actually keep outside the trust in your separate name. According to the rules in California, you can have, it's about $184,500 now. It slowly goes up. That's how much you can have outside of your trust without a beneficiary designation and still avoid probate. So if you add up all of the assets that you have without the beneficiary designation, it can be under $184,500 and still avoid probate. So that's kind of your freebie, all right? If it goes over that amount, then it's subject to probate. So all of your larger accounts, you'll want to title in your trust. Now, there's some assets that you don't title in your trust, and the main types of assets there are retirement accounts and life insurance. So those you keep in your own name. For retirement accounts, if you were to retitle those, then all the tax becomes due, and we don't want that, especially the pre-tax retirement accounts. So we're talking about pre-tax and Roth IRAs. For all of those, you keep the ownership the same, John Smith. And then if you're married, you'll want to continue to name your spouse as the beneficiary. So the spouse, so Jane Smith, she can inherit the IRA and then stretch it out over her lifetime, and she only has to withdraw required minimum distributions and pay the income tax on those withdrawals, right? So that's a nice way to postpone paying income tax. So you name your spouse first, and then you can name your children directly, if they're responsible, or you might want to name your family trust if you have young children, or maybe you have a lifetime trust built into your trust, so you can name your family trust. So that's something to work out with your attorney and also with your financial advisor. You can ask them about that as well. So you don't name the trust as the owner. Same thing for life insurance. John Smith would stay the owner, and then he could just name the family trust as the beneficiary. That's easy, right? There's no pre-tax issues there. So a lot of times we just say, name your family trust as the beneficiary, or you can name a spouse and then the family trust. If you're not married, obviously you're not naming your spouse. You can just name your kids directly, or you can name the family trust. Also, some people choose to name their child's special needs trust as a beneficiary, and this can be a really good idea too. Now, what if you have assets outside the United States? Well, for those assets, a California trust doesn't have jurisdiction over those assets. So typically you would need to prepare a will in the country where you hold the assets, right? And then that will control where those assets go in that country. And then we would put in your will here, we would carve out those assets. So we'd say, this California will does not cover the assets that you have in that other country. And you'd work with an attorney in that country to prepare this will. Now, what if you have a safe deposit box? That can be a great place to hold stuff because nobody can get into it, but it's also a challenge when you're gone because nobody can get into it. So for safe deposit boxes, I usually suggest having your successor trustee named to have access to the safe deposit box. So you can work with the bank where the box is held and make sure that there's another signer there who can access it when need be. Now, I always suggest that people keep a list of assets somewhere convenient. When we're preparing your trust, we'll actually send you a flash drive with PDF copies of all your documents. And on that flash drive, we have a fillable worksheet where you can type in all of where you hold your assets, the account numbers. That can be very convenient for the successor trustee so that they can find where you hold your assets. Otherwise, how are they going to know? So a lot of people in olden days, when we just relied on US mail, people would wait at the mailbox to see, okay, are there any statements coming in this month from this bank, or maybe quarterly statements? But nowadays, a lot of people have opted out of the mail system and they have electronic mail, and you might not be able to access that. So you really want to make sure that your successor trustee knows exactly where all your assets are and they're not going on a wild goose chase. Then for your online assets, I usually suggest that you keep a list of passwords somewhere safe. Some people like using some, password protected programs. I don't know. There's a lot of different technology out there. I am not a super technically savvy person. So basically, I have a list of passwords that I keep in a safe place. And then I let my successor trustee know where to find that list. And then they can go online to access the accounts that they need to and be able to do what they need to do. Okay, so some people ask, what about transfer on death accounts? Can't I just name somebody as the beneficiary of my bank account, for example? Well, there are transfer on death accounts. They're called TOD accounts, or sometimes payable on death accounts, POD accounts, and that's where you just name somebody or a trust directly as the beneficiary of an account. But I don't think that's as protective. First of all, it's harder to access. The person would have to use your durable power of attorney to access those accounts if you were incapacitated. And a lot of times banks don't like accepting durable powers of attorney. The other challenge is you have to keep track of who have you named, because if you name somebody as a beneficiary and then that person dies, and then you die and you haven't updated that, then that asset could go through probate. And we want to avoid that. So I usually suggest not using transfer on death accounts, but instead retitling your accounts in the name of the trust, and then the successor trustee can go to the bank, bring some doctor's letters if you're incapacitated, or a death certificate if you've passed away, and they can easily access your accounts. To learn more about estate planning in general, I suggest that you go to my video called Estate Planning Terms. What do they mean? And I'll see you over there.